In fact, the next position of determining institutions as public authorities under the Right to Information Act is looking at the non-governmental institutions vis-a-vis the purview of substantial funding. Now, we all know that to a larger extent, whenever government funding is extended to organizations, it is inevitable that these organizations' accounts are audited and sometimes could be audited by the Comptroller and Auditor General of India. And hence, on the fact of establishing non-governmental organizations or determining them to be public authorities under the Right to Information Act, an interesting complaint comes before the Central Information Commission in 2006. Now, kindly note, this was not an appeal, it was a complaint. And you will notice that while appeals are filed under Section 19 of the Right to Information Act, complaints are filed under Section 18 of the Right to Information Act. And the grounds of complaint could be that an institution has failed to recognize or come within the scope and ambit of the Right to Information Act and has not appointed a public information officer. And hence, Section 18 very clearly provides a right to citizens to make a complaint to the Information Commission directly in case they think that an institution has not come within the purview of the Right to Information Act and is not providing information. Now, a gentleman by name Pradeep Gupta on 7/8/2006 filed a complaint to the Information Commission against the servants of the People's Society. He said that this NGO, or as it was registered as a society, having its office in Lajpat Nagar, New Delhi, with a telephone number and a fax number, they are receiving and spending government money, but still did not have a public information officer. So he requested the Information Commission to inquire into this matter and come to the appropriate conclusion. Now, while we look at the servants of the People's Society, this society has been or was receiving funding from the government, and interestingly, part was that when one looks at the CAG Act of 1971, Section 14, Subclause 2, generally the Comptroller and Auditor General goes about auditing organizations who have been receiving funding from the government. And if they have received, say, probably more than 25 lakh rupees in any given financial year, such accounts could be audited by the Comptroller and Auditor General of India. So if any organization, be it government or non-government, receives such funding from government, either directly or indirectly, as the Section 2H clearly depicts, then its accounts is subject to the scrutiny of the government auditor, right? So in this case, to determine whether the servants of People's Society is a public authority or not, the matter was taken before the Information Commission. Now, interestingly, the total income of the society, varied from around 25 to 28%, right? And such grant money, the NGO claimed, did not amount to substantial funding, right? So, what were the grants that were received by the NGO? So, this was actually perceived by the Central Information Commission. The accounts were called for, and interestingly, the Ministry of Human Resource Development, Department of Culture, was funding this NGO, and that was the funding that was being received by the NGO right from 1999. Interestingly, the society was also running a Vidya Bhavan school, and this Vidya Bhavan school was under the provisions of the Delhi Education Act of 1973. And this school was also receiving grants by the payment of salary to the staff by the Delhi government, right? So it was not only this central government that was funding this NGO or society, but it was also the state government that was funding one of the schools that was run by the servants of People's Society. Interestingly, they also had a Memorial Academy, and the Memorial Academy had received a grant of nearly 1.2 lakhs from the Ministry of Education, Government of India. and this was a academy that was like a school for mentally challenged children, right? And this money or amount that was given by the Ministry of Education was utilized not only for running the school, but for serving certain clients of the society as well. The society also ran a Sevak Ram Gramin Seva Kendra. This also was receiving grants from the Directorate of Health Services. Now look at it. So many departments and ministries of the central government were giving aid to the so-called society called the Servants of People Society. Now, interestingly, the Sevak Ram Gramin Seva Kendra, which was receiving grant from Government of Delhi Directorate of Health Services, was utilizing these funds for medical facilities. And this was also something that was perused. Now, the society was running a creche, which also received substantial grant from Delhi Social Welfare Advisory Board. This was in the form of reimbursement of expenses that were incurred for the maintenance of the creche as well. Now, these were certain factors that were taken into account, and all the kind of funding were inquired into to determine whether such an organization, which is a society, which is not a department or a ministry of the government, which is not a government agency at all. However, it is definitely something non-governmental, but receiving funding from the government, right? So in those circumstances, should such an organization come within the purview of the Right to Information Act, right? So the Central Information Commission looked into the fact of what about an NGO receiving grant or loan from the Consolidated Fund of India? When departments and ministries provide finance to these organizations, they use the money from the Consolidated Fund of India or of the Consolidated Fund of the state, as the case may be in a given financial year, right? And if this is less than rupees 1 crore, or should not be less than rupees 1 crore, right? Or is not less than rupees 25 lakhs, and the amount of such grant or loan is not less than 75% of the total expenditure of that body or authority, right? In those circumstances, then it would be viable to hold such organizations within the purview of the Right to Information Act, is what the Central Information Commission had to look into. Now, in this case, the court gave a very important decision, and they said something like this. They said that nearly the school at least received 95% grant in aid, right? So that was quite substantial. It was more than 75% of the total expenditure of the organization as well. And the question of whether the organization's audit had to be done by the CAG, it was answered in an affirmative, right? And finally, the CIC held something like this. They said the Servants of the People Society itself, together with the Balwant Rai Vidya Bhavan, Senior Secondary School, Senior Citizens Home Dwaraka, Sevak Ram Gramin Seva Kendra, do not qualify as public authorities, right? However, the Balwant Rai Mehta Senior Secondary School does. Right? So they try to distinguish the various functions of or the different organizations that are run by this NGO, and they came to the conclusion about saying that the senior secondary school, which was receiving 95% grant in aid, should be declared as a public authority, whereas the rest probably do not qualify to be a public authority because they do not fit within the test of CAG audit. Neither do they fit within the test of receiving 75% of the total expenditure in a given financial year. So I think this judgment very clearly depicts that within a non-governmental organization's functions, again, the kind of functions or institution that it manages can also be segregated to determine whether it fits within the definition of a public authority or it does not fit within the definition of a public authority. Now, interestingly, when we look at the substantial funding definition, one must always make a distinction between what it relates to investment and what relates to running expenses, right? Now, we always say more than 50%, like in the Pradeep Gupta case, we applied the 75% of expenditure, as the case may be. Now, the quantum of finance to hold in a body being considered as a substantial funding is not specified. For the word substantial, it is not possible to lay down any clear or specific definition. It must be a relative one. However, substantial means real or actual as opposed to trivial. And substantial also means practical as far as possible. And hence, the word substantial should not be construed as higher percentage of the estimated amount or otherwise. This was held in the case of New Tripura Area Development Corporation versus the state of Tamil Nadu by the Tamil Nadu High Court. Right? Thus, emphasis made herein is the activity of a body must be based on its public duty. Right? That is very, very important. That's what has been held in this case decided by the Tamil Nadu High Court. Right. So after this, I think we should move forward and look at a very interesting aspect of whether sports body there are various sporting federations, sporting bodies can be determined as public authorities under the Right to Information Act. Now, the most prominent issue in this case comes from the Indian Olympic Association, a case that was filed by one Mr. Viresh Malik, and from the Central Information Commission reached to the Delhi High Court finally. Now, the case is the most interesting one on the fact that it was about an association that was in charge of the Commonwealth Games, or organizing the Commonwealth Games that was organized in Delhi in 2010. And unfortunately, post that led to the Commonwealth Games scam, in which Mr. Suresh Kalmadi unfortunately had to face charges of corruption in that sense. But this case, commenced even before that, and the RTA applicant just filed an RTA petition to the Indian Olympic Association seeking information, and unfortunately, that information was denied in that case.